Interested in some of the policy debate, certainly on intellectual property, given their important and valuable portfolio. And they have to face many of the strategic decisions literally on a daily basis that are involved with creating innovation, implementing new technologies in the market, and then moving on through R&D to do it all over again. So we're delighted today to have one of the very top folks at Qualcomm, General Counsel Don Rosenberg, who finds himself literally at ground zero in the innovation debate, and particularly when it comes to public policy issues surrounding things like intellectual property. So, without further ado, let me introduce to you Don Rosenberg.
Thank you, Professor Hazlitt. This has been a really interesting morning. I've been intrigued by the discussion thus far and the lectures that we've had. And as I was telling Professor Langlois at the break, I've been in the technology field my entire career, which goes back a longer way than sometimes I like to think. But I spent 31 years at IBM, for example. Spent a year at Apple, and now I'm in my 5th year at Qualcomm. And one thing I would just kind of throw into the mix of discussion that I think everybody has to keep in mind, I always like to think of time as a dimension that we all need to think about as we do the kinds of analyses that these professors have done. Time and change. And of course, change happens over time, sometimes shorter, sometimes longer, but everything changes. And I saw it through my many years in the computer field. I saw both the ebb and flow. I saw predictions of death. I saw predictions of monopolization. I saw predictions of great harm to competition. None of which really ever came to fruition. And I always remind myself and others that we need to consider how dynamic our free market system really is. And I think it's inherent in a lot of things that was said here. I had so many thoughts during each of the professors' presentations. I thought of Qualcomm for a minute as e-ink. When I came to Qualcomm, I remember my 80-some-odd-year-old mom said to me, gee, this is the first time you're working for a company that you have to keep spelling the name of for me. I've never heard it. But that's because we've never really been a consumer-facing company. We, in fact, were very dependent on others, operators, carriers, not only here, but all across the world, governments for spectrum, and of course device manufacturers. We're a supplier. But we're a supplier not only of the hardware, and I'll tell you a little bit about our history, but we're a supplier of intellectual property. And that's really I want to focus today, and I think talk a lot about intellectual property and talk a little bit about Qualcomm's business model, because they are completely linked. I hadn't seen any of the presentation materials before, but Professor Langlois talked about innovation, and I'm starting off by telling you that, in my view, innovation has become a somewhat overused word. It seems that anyone who wants to evoke a positive response to her position, especially in the business world that I'm involved in, inserts that word at the appropriate opportunity. Everybody is innovative in some form or another. But it means a lot of different things to different people. And innovation can take different forms. You've seen some of that already. Everyone will say they're pro-innovation. Who could possibly oppose creativity and progress? But I like to think of innovation as a chain with value added at each stage. It starts with an invention, often a disruptive invention, which is the necessary first link. And indeed, it's often the anchor The patent system provides incentives for innovation through protection of original, novel inventions. As President Lincoln said, the patent system added the fuel of interest to the fire of genius. This anchor, this foundation, is only obtained through costly and risky efforts and should be distinguished from the later invention and incremental improvements that occur upon commercialization of a patented technology. If incentives for basic R&D are weakened and fundamental inventions are never realized, new product development will inevitably decline. And ultimately, it is consumers and the American economy that will be negatively impacted. We've heard today, as I said, about different perspectives and points of emphasis. But I think at the core, certainly when you think about intellectual property, is the recognition of its critical role and of a critical role of the patent system, which is the foundation for evolving patents that we've talked about today. Excuse me, platforms that we've talked about today. Even so, I think we are at an inflection point, and we've been at this inflection point, frankly, for the last couple of years. So it starts to be something more than an inflection point, I suppose. And it's regarding the direction we're heading in innovation policy and IPR protection in the United States and indeed globally. I see troubling signs that the proverbial pendulum is swinging toward a weaker patent system, not the one contemplated in our Constitution, promulgated by Congress, and shaped by over 200 years of jurisprudence. I fear the potential consequences for the U.S. economy and competitiveness as a whole, for job creation, and for our dynamic culture of innovation. With new technologies and new industries, we are bound to see complicated clashes between IP rights holders and those who want to exploit the underlying inventions, many of whom see themselves as innovators insofar as they commercialize and improve upon inventions of others. These conflicts are not new, and as always, they raise difficult questions about the appropriate balance of rights and obligations among various stakeholders, as I just mentioned. What is critically important, excuse me, is that we take a long and broad view, recognizing that seemingly expedient policy changes intended to enhance static efficiency or in response to highly publicized controversies can profoundly harm our system of innovation and the development of disruptive inventions and dynamic efficiency. As you know, I've spent, and as I've said, I've spent my entire life in the technology field, often at the intersection of intellectual property and competition law. When I got to Qualcomm, I found a company that has, as Professor Heslett has said, from day one been driven by a desire to make dramatic changes in the way people work, in the way people live, and in the way they learn. It's first and foremost an R&D company. We have 65% of our employees are engineers. Led by Irwin Jacobs, 7 visionaries developed the technology that today powers more than 1.5 billion third-generation or 3G mobile devices. In 1985, when Qualcomm was formed, just a little over 25 years ago, wireless service was plagued by severe capacity constraints, too little spectrum to support reliable and affordable service. Qualcomm started without a specific product in mind, but with the determination to innovate in digital and wireless communications. And within a few months of founding, Dr. Jacobs was struck with the idea that something called Code Division Multiple Access, or CDMA, might provide a significant advantage over the more traditional digital technologies. By enabling reliable, affordable service, CDMA had the potential to cause an explosion in the nascent wireless industry and fundamentally change the way we live and work. This is easily said, but not easily really understood. It was an enormous step that Professor Jacobs saw in the use of this technology called CDMA. CDMA is a great example of what has often been called disruptive technology. There were impediments, and these impediments rendered CDMA, in some people's minds, unsuitable for commercial application. Professor Heslett mentioned that before, and I'll tell you that they were so daunting, or seemingly so daunting, that a professor at Stanford has famously been quoted and proclaimed at the time that Qualcomm's vision of CDMA use defied the laws of physics. Professor Jacobs has often cited that quote with a smile on his face. Needless to say, the deep and widely held skepticism about CDMA rendered the investment in Qualcomm a very risky undertaking at the time. Yet despite enormous odds and unrelenting opposition from entrenched industry participants who were committed to other technologies, Qualcomm ultimately was able to raise the necessary capital to continue its work. Why? Because the patent system offered the promise of market-based rewards if Qualcomm's solutions allowed the potential of CDMA to be realized. The first commercial CDMA network began operation in the fall of 1995, and that was in Hong Kong. Still, there remained considerable doubts about CDMA and opposition from members of the entire wireless industry who were invested in other technologies. Well-known manufacturers of handsets and infrastructure equipment, big names at the time, Nokia, Ericsson, Motorola, they had invested in other technologies and were reluctant to develop and sell CDMA network equipment and handsets. Qualcomm thus had to start and operate its own infrastructure and handset business. We literally at the time entered into the business of infrastructure creation and handset development. Rejected by industry and governments in other jurisdictions, CDMA was adopted by the South Korean government for the next generation of wireless networks in that country sometime after it was established in Hong Kong. Soon, South Korea was renowned for having the most advanced wireless networks in the world, and that actually continues today. Following that success, CDMA was adopted in the United States and elsewhere around the world. By the time the EU was considering technologies, and that EU at the time was really the center of wireless technology development and implementation. European operators were demanding the same kind of capacity performance that was being experienced on CDMA in Korea and Hong Kong. But still, the entrenched 2G, second generation GSM players led a European coalition toward a standard that attempted to bypass Qualcomm's 3G innovations in IPR. So there was a huge fight in the standards bodies that were regulating this area. Essentially, the EU was intent on locking out at the time what was viewed as American technology and keeping European technology in Europe. At the same time, the European standards body that I mentioned, called ETSI, announced a preliminary decision requiring its members to use a 3G standard, not the Qualcomm CDMA technology. This move prompted a response from the U.S. Secretary of State, the U.S. Trade Representative, the U.S. Secretary of Commerce, and the FCC. Europe sought to parlay its GSM technology, its strategy, and an installed base to dominate 3G mobile telecommunications. In January 1999, the EU Commissioner said in a classic example of post hoc rationalization that the EU's intent was not to lock out U.S. players, but only to ensure that at least one operator in each European country would use compatible technology so that European phones would work all across Europe. There was this discussion of something called backward compatibility that seemed to prevail for a while in Europe. A few months later, though, Ericsson and Qualcomm, who were embattled in patent litigation, reached a global resolution. And this supported a single world CDMA standard with 3 optional modes for the next generation of wireless communications. That single world standard incorporated and relied upon the innovations pioneered by Qualcomm, which became the basis of all 3G wireless technologies deployed today. So that's a kind of little boring recitation of the history, but it was, and I've talked to the people who lived through it at the time, it was a long and not at all optimistic battle they were waging at the time. Today, just to make the point, there are about 5.7 billion wireless subscriptions throughout the world with 6.7 billion people. With $1.3 trillion in annual industry revenue, mobile phones have simply become the largest platform for technology and information in history. And that is continuing. 1 year ago, we reached a key tipping point. The number of mobile broadband internet subscriptions surpassed fixed-line users. In fact, as we go around the world, and I do a lot of traveling to both developed and developing countries, one of the key points that is discussed constantly, especially in developing countries, is that people's access to the internet, for the vast majority of people throughout the world, is going to be through the cell phone, not through a PC, not through any other device. So as our history shows, innovation is what we're all about. And having put more than $18 billion in research and development over the past quarter century, we're committed to continuing to innovate and evolve the mobile experience. As a leading developer and supplier of chipsets for mobile devices, we are innovating at all levels of the value chain. Yet we are mindful that it is dynamic, sometimes disruptive innovation that has the greatest potential to significantly improve people's lives. Looking beyond 3G, we are actively pushing the envelope and contributing to the launch of so-called fourth-generation wireless innovations. And this is a technology that you'll hear called LTE, long-term evolution. But Qualcomm's experience in those early days as a small startup illustrate the close relationship between intellectual property protection, innovation, and economic growth. Qualcomm's success was dependent on negotiating royalty-bearing license agreements with some of the largest companies in the world: AT&T, Ericsson, Sony, Panasonic, and Motorola, just to name a few. But how could such a small, young company, even with a great new technology, navigate a marketplace dominated by these industry giants and ensure that if these established and powerful players wanted to make use of the technology, they had to agree to license it? The answer was, and still is, rooted very strongly in our strong system of patent rights and remedies. Our experiences shaped the company's philosophy, which continues to this day. We are a champion of the rights of individual inventors, small entrepreneurs, universities, and all those who value the importance of intellectual property protection and recognize its essential role in encouraging innovation. I cannot stress enough how strong intellectual property rights make this global proliferation of mobile innovations possible. Qualcomm's philosophy was, and still is, to enable many other companies in the wireless value chain to succeed. That is the source of the licensing business model that has generated our continuing R&D investments, and today accounts for 65% of our company profit. I like to talk about it as a cycle that is virtuous, in that, as I said, we've got an enormous number of engineers, enormous number of R&D efforts ongoing. We invent, we protect using the intellectual property system of the U.S. and the rest of the world. We license our inventions by licensing our patents to others. We collect royalties, and we invest an enormous amount of that back into the R&D that produces new inventions. Our royalties make up something like 65%, as I said, of our company's profits. Today we have more than 200 3G licensees globally, and that includes pretty much every company in the telecommunications sector. And as I said, we reinvest about 20% of our annual revenues, which was about $3 billion in 2011, in research and development to maintain that technological leadership. So critical to this innovation is the system of risk and reward, as I mentioned earlier. Qualcomm shareholders allow us to take risks, like investing 20% of our revenue in R&D, based on the confidence that if we successfully innovate, a strong patent system will allow us to earn a reasonable return on investment. We believe this investment benefits the overall development of the wireless industry, its ecosystem, and enables companies all over the world to profit from enhanced domestic and global market opportunities. As patent holders, the philosophy from the beginning and continues not to take advantage of what the patent law would permit us to do, which is to exclude others for a period of time. We do that in some sense, of course, But we decided a long time ago that we wanted to license our patents broadly in order to expand the industry that we lived in, obviously, for both self-benefit as well as industry benefit. And that model has worked. But today, access to funding is scarce, and it's getting scarcer. There's a need to ensure that risk capital is available for research, development, and commercialization. Of course, again, the main motivator of risk capital when looking at investment opportunities is return on investment. We've heard a little bit of that today. If there are limits on or uncertainties about return, whether through weaker intellectual property protection, regulatory intervention, or other factors, capital will not flow to markets, and disruptive innovation will suffer, affecting our prosperity and quality of life. All stakeholders, industry, governments, NGOs, academia, and all other international institutions should have a shared interest in preserving incentives to innovate and propagate new and useful inventions. As our founder, Dr. Jacobs, said, without such incentives, we will measure the cost by the bells that don't ring, the cures that are not developed, and the technologies that are not invented. In the long run, society will be the poorer for it. Qualcomm's experience highlights the critical importance of the incentive structure that underpins the patent law, motivating investment to achieve ongoing dynamic efficiency rather than insisting on optimizing static efficiency. If courts or agencies in the U.S. or abroad had intervened in the 1990s to change our patent laws to artificially drive down the value of patents or reasonable royalties, then Qualcomm may not be where it is today. Without our ability to earn royalties on 2G CDMA, we might not have been able to invest so heavily in 3G, and the industry and consumers would not have reaped what we see as such rich rewards. Strengthening, or at least preserving, incentives to innovate and enhance dynamic efficiency should be viewed today as a national priority. IP has become our #1 export. As USPTO Director David Kapos has so aptly put it, intellectual property is the global currency of innovation. Today, the United States invests more in intangible assets than any of our major trading partners. Our intangible investments now exceed tangible assets by more than 20%, a trend that is likely going to continue and even accelerate. And we are the envy of the world. Developed and developing countries are actively trying to emulate our success. Just look at the rate and number of patent applications emanating from China. SIPO, the Chinese Intellectual Property Office, has data that shows that from the years 1997 through 2000, foreign invention patent applications exceeded domestic applications, that is, in China, by a significant margin. So companies like Qualcomm and others were applying for patents in China at a much greater pace than any Chinese companies. But by 2001, Chinese applicants had caught up to their foreign counterparts, and since 2005, they have dominated the Chinese patent landscape. In 2008 and 2009, domestic applications exceeded foreign applications by a ratio of more than 2 to 1. And that's a very short period of time for that change. And this trend clearly has its roots in China's focus on R&D investments and the emergence of leading Chinese companies, such as Huawei, ZTE, especially in IP-intensive industries. There's also an intensity with which Chinese companies are seeking IP protection outside of their home borders. The Chinese government reports that overseas filings by Chinese inventors increased dramatically in 2008. Chinese applications were up 34% at the European Patent Office, 16% at the Japanese Patent Office, and 14% at the U.S. Patent and Trademark Office. So as we sit here today, U.S. innovative leadership and competitiveness are threatened by at least two forces. First, by global efforts to emulate our path to leadership. That's fine. That's a good thing. We like competition on the merits. And second, by a growing trend, in our view, to devalue established intellectual property rights. This takes a couple of forms. The patent reform debate of the last several years was often co-opted by those more driven by concerns about damage awards than patent office efficiency. Fortunately, the final statute included no real changes to how patents should be valued in the marketplace. But the forces that fought for change continue to find other opportunities to press their case. They lobby governments, particularly competition agencies, to regulate the value and licensing of intellectual property. They would substitute government regulation for free market forces. Yet even well-intentioned governments, or branches of governments, periodically take policy positions to advance the agenda of certain types of business and certain types of business models as it relates to intellectual property rights and their use. And they do this without fully appreciating the adverse and perhaps unintended consequences for other business models and the potential impact on our economy. You saw some examples of various business models. You've got a vertical business model. Apple is a primary example of that. You've got interesting examples of horizontal models, and you've got some that are somewhat in between. You've got some interesting phenomena going on in our industry at the moment with basically three platforms, if you will, developing. You've got Apple, but that's closed. You've got Google and Android, which they describe as an open system. It's another factor I would throw in, by the way. Overall, looking at these issues, time, change, look at the individual company's particular focus. Look at where their business model leads them. Google is open as long as it can earn the revenues it wants to earn in the ad position that they have. And finally, the third platform that's developing now, of course, is Microsoft, which has had some slow uptake in terms of its recognition of the need to transform itself into a more mobile company. So these different models all can coexist, and they're all worth looking into. But what we're concerned about is that there is some form of business model neutrality when it comes to regulation. Antitrust agencies in major technology regions, whether they're in the United States, Europe, Korea, are to different extents considering recommendations that could be significant departures from what is existing policy and well-settled law. Policymakers should not be unduly influenced by the voices of a relatively small number of companies whose policy prescriptions may not be in the best interests of our innovation-driven economy. Misguided calls for government intervention could undermine incentives that drive and reward innovation. Some foreign governments already use guidelines and regulations to skew competitive conditions to benefit homegrown companies. In the U.S., decision makers need to consider carefully the broader implications of government intervention that could weaken the U.S. company's ability to compete in a global market. Foreign governments and competitors are watching us carefully. Without trying to attack or sound like I'm attacking any particular agency, take a look at the report issued by the FTC just last year. In our view, it calls upon U.S. courts to alter the balance between intellectual property and competition law in a way that appears to ignore well-established legal principles. It seems to ignore the will of Congress, and it seems to ignore the benefits of a free market to a thriving knowledge-based economy. Among other things, this report has picked up the mantle of the patent litigation reform movement and has recommended some of the very same changes to patent valuation that were rejected by Congress in the debate leading up to the America's Invent Act, which was the act that finally came about as a result of years of the patent reform debate. But our current U.S. system is working. It promotes technological development and is constantly evolving to meet the needs of stakeholders as it drives the U.S. innovation economy and the creation of jobs. Meanwhile, other governments have articulated positions and policies intended to shore up their domestic innovators. In so doing, they are rendering normative value judgments that certain types of businesses or uses of intellectual property rights are more worthy of support than others. Given the pace of technology and other factors, this is a dangerous proposition. Consider the recent developments in the U.S. Certain name-brand blue-chip companies of the 70s, 80s, and 90s that prided themselves on routinely being among the top 10% applicants for patents, as well as being robust manufacturers, have in recent years evolved their businesses and their business models. These entities that once lobbied for R&D subsidies and strong patent protection are today arguing for the devaluation of intellectual property rights and draconian restrictions on patent rights, because third-party patent rights may increase their costs and affect their profitability. This is fundamentally unfair. It's like having incumbent corporations raise the drawbridge to the next generation of disruptive innovators and deny tomorrow's success stories the same rights and remedies that the now well-established companies once enjoyed when they were young and vulnerable. There are ample examples of governments that enact policies to support local champions who are today licensees of foreign technology by pressuring the licensor to transfer its IP on non-commercial terms. While authorities may think this is the right policy for the short term, many developing economies know that this approach is ultimately counter to their long-term interests, as their own industries gradually move up the value chain from manufacturers to innovative sources and owners of their own intellectual property rights. It is dangerous, in our view, for government officials to make normative decisions about which IP-centric business and licensing models are superior based on a snapshot at any given time of their place in a dynamic market. Rather, government should recognize that innovation comes in many different forms and business models, and ensure that their policies are business model neutral and enable the evolution of technology value chains on a global scale. We have the ability to meet these new challenges, but we do so without inflicting a damaging blow. We must do so, excuse me, without inflicting a damaging blow to our innovation economy. That's my prepared remarks, and I'm happy if there's any time to take a couple of questions.
Why don't we just take a couple of questions? Do we have questions?
I understand how a hardware manufacturer could be, support the current patent system because hardware development takes a lot of R&D. It takes a big company to do it. I hear from a lot of software programmers that they wish the patent system didn't exist because a lot of them feel that it's choking their productivity and their creativity. So, because a lot of software development is done by people tinkering around, and they do a lot of copying of what has come before. So, what do you have to say to people in that type of situation?
That is a big and complicated question. It goes into a lot of things, such as whether patent law is the right thing to protect software development. I've seen the evolution of protection of software from pretty much nothing to copyright, or trade secret protection to copyright to patent protection. And in the software area in particular, it's been a difficult area for practitioners to find and amass enough understanding of prior art so that even if they inadvertently are copying, someone might be able to avoid that. You say copying or using what existed before. Using what existed before and building on it is okay. I've heard for a long time, and that goes back a lot of years, from developers that they feel that intellectual property rights somehow get in their way. I don't believe that there's enough good empirical evidence to support that. Copying is copying, and unless we decide that copying is something that we want to legalize and make legitimate, I think people have to understand that they have to find ways to not just copy, but to build on what pre-existed. So I don't know that I could answer it any better, not at least in the short time we have here. Yeah, yes?
I share very much your view here about the dilemma and the history and the development problems and lack of focus on this real risk-taking in disruptive technology, as you phrase it. But my question to you is, do you have any suggestions for remedy of this problem, that basically if you companies take control of the legislative body in a sort of Douglas North fashion and tweak the rights in their favor for marginal invention. This is, by the way, exactly what happened in 1954. The pharmaceutical companies tweaked the law and changed from fashion genius to non-obviousness because they wanted to have long toil, revenues on long toil, rather than innovation. So I think what you're describing is very similar to that. Do you have any suggestions for remedy it right now? Where the market is more global? I mean.
Yeah. Well, your last point, the fact that the market is so global presents enormous problems for businesses. You end up having to regulate yourself and adjust your business to what might be called the lowest common denominator. We see that in competition law, and we see that in intellectual property law. Competition law, for example, years ago, I was an antitrust lawyer in my early days, and years ago, I could give advice to the company because I knew what the U.S. courts were going to do in terms of applying antitrust law. Now there are over 100, and God, I don't know how many, but I know there are well over 100 competition regulators throughout the world. All of them have their own statutes, their own regulations, and their own rules of enforcement, and their own cultural predilection as to how they will enforce. So it's very difficult for companies who are global companies to try to manage their business and their practice and be comfortable and confident that they're not going to run afoul of those kinds of regulations. And competition law is just one area that is prevalent in my mind, but there are other areas. Intellectual property is another. That law is developing elsewhere. We're trying to come up with, as lawyers, some kind of coherent way to advise clients as to what they can and can't do when it comes to intellectual property. I personally think, as I said in my remarks, the system has worked for a long time, and we were in the patent reform debates that went on here in the U.S. We were of the view that what we ought to try to do is reform the patent system to make it more efficient, so that it produces better patents, it produces them faster, it decreases the backlog. But we thought it was a huge distraction for many years to try to really get what was really patent litigation reform as part of the patent reform movement. And the way they were trying to do that, as I alluded to, was to largely focus on damages, raising all kinds of specters of too much litigation and too many damages. I'm not a fan of litigation, and I certainly don't want to pay high damages. On the other hand, at the end of the day, if you've proven somebody to be an infringer of what's been established as a valid patent, and that person has refused to pay a license fee or do what is required by the law, there has to be some consequence to that. And if you make that consequence so trivial, all it does is encourage that kind of behavior over and over again. And so, you know, my view is, frankly, the less government regulation and the less attempts by government to try to modify behavior, the better off we are. I think the market does a pretty good job of that. And eventually, as I said, over time, all things change. In our industry, we are, I was at Apple just as the iPhone was being introduced. There was no Apple, there was no iPhone in 2006 and half of 2007, right? It's hard for anybody in this room to kind of think of mobile technology without thinking of Apple today. Nokia was king then. Nokia is struggling today. Motorola had the Razor phone. You don't hear very much about Motorola. They're trying to make a little comeback now. Of course, now that Google's bought them, who knows? So things are changing rapidly. We are, I think, our industry is the best example of dynamic competition at work, and I think the more governments kind of stay back and allow that to happen, the better off we are. Thank you.
Please join me in thanking Don Rosenberg.